Hi, everybody, and welcome to our panel today. My name is Amy Lewis, and I am with the Pew Charitable Trust in the Civil Legal System Modernization Project. And today we're going to be talking about implementing online dispute resolution in state courts. And I have three other panelists with me here today that I'd like to introduce to you. We have Michelle Acosta from Hawaii. She's the Chief Innovations Officer and Special Assistant to the Administrative Director of the courts. If you want to say hi, Michelle.
Hello, Amy. Thanks for introducing me.
We have Sharon Sturgis, who's the Director of the Office of Dispute Resolution in the Colorado State Court Administrator's Office. Hi, Sharon.
Hey, Amy and Michelle and Stacy. I'm really looking forward to the panel today.
And last but not least, we have Stacy Mars, who's the Administrative Director of the Alaska Court System. Welcome, Stacy.
Thank you. I am delighted to be here.
Thank you. So what we're going to be discussing today is we're going to define what Pew and NCSC call court online dispute resolution, or court ODR. We're going to talk a little bit about our approach to implementing it, and then Michelle and Stacy and Sharon are going to share with you a little bit about their state projects and how they've gone about implementing or planning to implement ODR in their states. And then we'll kind of come back to the panel and join them for some question and answer discussion about specifics of their implementation and give you guys an opportunity in the audience. Please feel free to chat any questions as well. We'll be moderating and answering those in real time. So we would love to hear from you and love to know what you all are thinking about. And so with that, the thing that really sparked Pew and NCSC getting involved in online dispute resolution or these kind of court technology projects is the fact that courts have expressed, and we have found that they need help kind of meeting their changing circumstances. Litigants are changing. You know, the civil legal system is outdated, and when most people resolve civil disputes with today, they do it without legal help. More and more people are forced to represent themselves in civil matters in a court system that was built for lawyers by lawyers. And so on a study that NCSC did in 2012, approximately 75% of cases, or 3 out of 4 people, were representing themselves in civil disputes. With more than 30 million people in the U.S. attempting to navigate civil legal issues in state courts without the help of a lawyer, courts really needed to think about ways that they could adjust, meet litigants where they are, and ways that they could kind of expedite their process and help unrepresented litigants in particular know how to move forward and navigate court procedures and policies. So with that, we saw kind of what we call the rise of online dispute resolution in courts. And you'll see here that there's kind of 3 tiers. We have some states that are already implementing ODR or that have at least one ODR platform. States that Pew and NCSC have been working with that have launched or are launching pilots in the near future, particularly Texas, Florida, Iowa, and Hawaii. And then some other states that are exploring ODR, like our partner states, Colorado and Alaska, among others, Kansas, Kentucky. And then Michigan, we're also working with, but they have several ODR pilots or platforms already in place. And so we see that ODR has rapidly risen as a response to trying to meet litigants where they are and kind of modernize the court system. The thing that Pew and NCSC noticed is that as these ODR tools were kind of rapidly proliferating, there was no overarching or set or standard framework for how courts should really navigate implementing these tools and what guidelines that they should follow. And so Pew and NCSC decided to set out to first define what is court ODR. And we have defined court ODR as a platform that is court annexed, meaning that it's supported or hosted by the judicial branch, public facing, meaning that it's open to anyone. It's not just for attorneys, and then it's a fully online or digital space where people can resolve their disputes. And so once we define court ODR, then we had to think about what does it mean to actually implement ODR and how should courts really go about doing that. And that's part of how the Civil Legal System Modernization Project at the Pew Charitable Trust came about, was to really help courts and to partner with the National Center for State Courts to think about ways that courts could technology to address some of their needs, but do so in a way that didn't exacerbate harms or replicate or create further harm. So really quickly, just to give you a brief introduction to the Pew Charitable Trust, we are a public charity that focuses on evidence-based research and fact-based solutions. We do policy work, and the kind of joke about Pew is that we do anything from pensions to penguins. So the Civil Legal System Modernization Project is one project of the Pew Charitable Trust where we're doing civil legal issues and then providing technical assistance to courts. And when Pew and NCSC thought about online dispute resolution and the research that they wanted to do and what kind of technical assistance they wanted to provide, it really centered around the promotion or adoption of ODR fundamentals or guiding principles and helping courts implement those successfully, and then ultimately evaluating how effective they are. There's been one evaluation released on usability recently around Utah's online dispute resolution that was sponsored by Pew, but to date, there have been no other comprehensive or full-scale evaluations launched to really determine what the benefits or challenges of ODR might be, particularly in a court setting. So Pew wanted to work with partner courts to help determine what these principles should be and then evaluate where courts could go from there. So Pew and NCSC really focused on three core fundamentals, the first of which was inform, which meant providing users with legal information and referrals and making sure that information was included within the platform, that it was right-sized and plain language. So whether that's procedural or substantive information or both, making sure that litigants are equipped with the information that they need to successfully navigate their court cases, and to have off-ramps or know to contact an attorney if they really need. The other piece is notify or notice, and that's ensuring that courts are properly notifying parties of their case, but also on online dispute resolution. And you'll see there's a lot of overlap here with information, that when parties are notified of online dispute resolution, that it's really crucial that they have the information they need to be able to online successfully, to understand the process as a whole and understand what their rights are within the process and how they can proceed with their case. And then ultimately, the last one is review, and that's ensuring that ODR does not do any further harm and that the rights that people have when they are interacting with the court system are maintained, even when these procedures and policies go online. So especially if a court is enforcing the order, that a judge reviews it. This also could mean that like mediators or third-party neutral facilitators are making sure they're adhering to ethical standards that they would in a traditional court setting. And just making sure that those controls are built in so that when the court process goes online, that people still maintain their same rights to appeal and their right to due process. So recently, CCJ COSCA, or the Conference of Chief Justices and court administrators, promulgated a publication that's called the Guiding Principles for Post-Pandemic Court Technology. We've certainly seen that COVID-19 has shifted the way that courts operate and has seen even more courts going online, not just with online dispute resolution, but whether it's, video conferencing or remote hearings. And they've set forth some guiding principles, some overarching ones, and I'm certainly happy to share with you the larger documents, and I can drop it in the chat for you too. But the biggest factors that you see coming out of that is that technology and innovation should really be court-driven. So when ODR first came on the market, we saw that it was largely in the private sector or business to business, or thinking about e-commerce, places like eBay. But when courts have a different duty to the public, right? And so when we think about what vendors are pitching or what they may have to offer, the courts need to really be thinking about what their unique needs are and making sure that vendors are able to accommodate or build in the features that they need, not just necessarily taking an off-the-shelf product that wasn't designed with the court process in mind. And then, as I kind of mentioned with the review, making sure that online processes align with court rules and procedures. So when you're moving technology online, it's not as simple as just slapping technology onto old business processes. And as you'll hear from our panelists, there's a lot that can be done to review and simplify court business processes, but ultimately making sure that the online process does align with the traditional court process in terms of rules and procedures. And then really just thinking about a user-focused implementation and design. And again, I'll let our panelists talk more about that. And I think you're going to hear that as an ongoing theme today, is thinking about who the platform or who technology is really designed for, that it's not just necessarily about making the court more efficient or getting more cases through, but it's really thinking about things from a person-centered place and thinking about how people actually navigate the system, whether that involves bringing users in at the beginning of the design afterwards, as we saw with the Utah court study, to make sure that people are able to utilize the platform in a way that's beneficial to them. And as P would also assert, is just really taking that data-driven approach. So right now we know that things are new. We know that courts are on the cutting edge of implementing this technology, but where possible to internally evaluate, and if also possible to have a third-party external evaluator to really establish metrics and think about if what you're doing is actually working, if it's meeting the goals and objectives that you set out to do, and making sure that there's the data to back that up. And so with that, I'm going to turn it over to our panelists. Each of them are going to talk about what they've uniquely done in each of their states. I think that you'll see a lot of similarities, but also hear some unique applications of how they're implementing ODR projects in their states and how they've worked with PU and the National Center for State Courts to really implement some of these guiding principles as well. And first up, I'm going to turn it over to Michelle from Hawaii.
Thank you, Amy. Just to give you a little bit of a background for our state, we are the 50th state, and we are one of the most isolated spots on Earth. We have 8 major islands in a span of 137 volcanic islands in our state. We have a unified judiciary branch here falling under our Chief Justice, Mark Rechtenwald. And there are 4 circuits that span across the 8 major islands in our state. We are a beautiful state. We have a beautiful land here, and ocean and beaches, but we also have a very high cost of living. And so the way that we are looking at ODR and simplification of processes and making the courts more accessible to our population is really keeping in mind the population that we have here in the community that we serve. When we first discovered ODR for courts was way back in 2016. Our Chief Justice and several of our district court judges were attending e-courts, and they happened to be viewing a panel from Utah, Michigan, and British Columbia, and were really inspired by their experience and their thought process in incorporating ODR into their judicial business processes. So from there, coming home to the state of Hawaii, after the conference, Chief Justice wanted a group of judiciary employees to take a look at ODR, and this was led by one of our district court judges here. And some of our earlier considerations was, why would we want ODR in Hawaii? Who is it going to be for? Why are the services and programs that we have not meeting some of the needs that we're identifying for ODR? And then who do we need for this project? So at the very onset, our Chief Justice really was looking at ODR as an access to justice tool, and certainly considering our population that there are a lot of self-represented litigants or unrepresented litigants who can't afford legal services. And so this was really going to be something that would be made available to people who don't have the resources to access legal assistance. So, and really thinking about who we're building this for, and what are the needs. The high cost of living in Hawaii has a lot of our community members working several jobs. And so coming to court, while it is important, sometimes falls behind on their priority list of childcare, getting to work. And so some of those barriers were really something that was affecting their means to resolve their legal issues. So really looking at that and looking at what this tool can really bring to their community to make the courts accessible was something that we really wanted to think about in terms of what system or software or application do we want to adopt for the judiciary. And also in looking at what we already have, the state of Hawaii is very lucky to have great partnerships between the public sector and the private sector, and also our legal service providers and social service providers. So there's a lot of information that's been put out there. We were working with the Justice for All grant that brought in a lot of our community partners and making sure that legal information was out there for the community to be able to identify legal issues and find their way to resolution. We also have existing interactive court forms. We also have a long history and relationship with our mediation centers. So looking at that, how ODR might fit in is that we really wanted all of these different components that existed within our community to be really streamlined and connected with each other, so that a person who is looking at a civil legal issue didn't have to bounce from one system, one application, one organization to another, but can go through the process from beginning to end in a streamlined way. So in looking at how do we get started, who do we need, one of the things that we really identified was that we needed a champion within the judiciary to really push this initiative forward. I think that's one of the more important things that you would need to consider in launching a program in your court, in your jurisdiction, is to really have that one person who's going to advocate for the project. And so fortunately, our Chief Justice, Mark Rectenwald, has been a real champion for this. He designated our now retired Judge Mona Lee to lead this effort moving forward. We also knew that we needed to get internal stakeholders, subject matter experts, external subject matter experts on board, and also think about the buy-in for both internal and external users. So those are the things that we were thinking about earlier on as we were developing this. Again, we started in 2016. A group of judges and court administrators actually traveled to Utah to do some observing with Utah courts there and how they were thinking about implementing ODR. So as we thought about the needs and who and what and why we were doing this, we started again looking at other jurisdictions like Utah. At the time in 2017, there weren't a lot of jurisdictions that were implementing ODR. So we were looking at international courts and see how they were doing this. We attended a lot of conferences where ODR was being talked about. So that was actually really useful to be looking at all what was happening across the country and even internationally. Having kind of put together a concept of what we wanted and what we were thinking about, we did bring in our IT department and started talking about whether we wanted to build an ODR platform similar to Utah or to buy something that was off the shelf. We also thought about whether we wanted to integrate that within our case management system or have a standalone system. And so a lot of this was really helpful to have a sit down and a real conversation with our IT department to see what their capacity was to build an ODR platform. At the time that we were having this discussion with our IT, we were going through a transformation with our civil e-filing system. So our IT department really didn't have the capacity to take on another project of this new ODR system that we really didn't have as much information on how to do it at the time. So we thought maybe looking at commercial off-the-shelf products might be the way to go, since we can move that forward, something was out there, and we can get it going faster than waiting for our IT department to become available after they did the civil e-filing system. So as we were doing that, we started looking at vendors out there to see what was in existence. Again, in 2017, there weren't a lot of vendors that were in the ODR market. But as we moved along, there were more and more coming into the market. And so we were able to do additional informational gathering at that point. So we did go through an RFI, request for information process, which we plotted down in our many different workflows and identifying our requirements, and put that all together in RFI and put it out there to see if there was any vendor that could piece together all the different things that we wanted our ODR platform to do. So fortunately, we had a good number of vendors who responded, including some local vendors, programmers that presented to us different ideas on how to get all of the requirements that we thought of that needed to be part of our platform, which were interactive court forms, online payment, making sure legal information was available throughout, sending out reminders, and getting through case resolution and case review for our court staff. After we did get the responses to the RFI, we went back again to our workflows and to making sure that we understood what the requirements were for our stakeholders, both internal and external. And then we put together an RFP. So that RFP went out pretty much with a little bit more refinement from the RFI as to what we were looking for. And from there, we were able to procure an off-the-shelf vendor product, and we are now in the process of implementing that. But throughout this, I wanted to share with you that the process redesign is something that was really a repetitive process, that you do have to have some patience with that and be open to learning more and making sure that if something that made sense at the beginning of your planning stage doesn't make sense during your implementation stage, to be ready, to be flexible, to make sure that aligns with your initial goal and main goal. And for us, that was for making sure that we have an access to justice tool that was really geared towards underrepresented litigants. And so I'm showing 3 samples of our workflows and how we plotted it out through many different versions of our spreadsheets. And that was just the process that we went through to hopefully get it to as close as possible to what we have been envisioning as an access to justice tool. And also considering what type of case type you would want to launch this for. We did take a look at the rule changes and the different case types that it might apply to. Our goal was to get an ODR system up and going sooner rather than later. And so we were looking at a case type where there wasn't going to be a lot of rule changes that would take place. So with that, we decided to move forward with a pilot project with small claims. And this is for the state of Hawaii. It's monies owed for less than $5,000, and it also includes residential security deposit disputes. We selected small claims because it has a high number of self-represented litigants. It's also low risk in terms of the monetary dispute involved. And it also, actually, when we looked through it, we only had to change one rule. And so it was something that fit a lot of our criteria in starting up a pilot project and an online dispute resolution. What we ended up doing was coming out with a process or a system that really provided a step-by-step an end-to-end service for our court users from beginning to end. So we wanted a platform where a self-represented litigant would be able to initiate their small claims case, be able to be guided through the court forms so that there was no mystery as to which court forms they needed to fill out, how they needed to fill that out. And then we also wanted a component where they would be able to pay the filing fee online or request a filing fee waiver. Along the way, we decided that we wanted to be even more flexible and allow for a process for court users to be able to pay that fee online, in person, or via mail, so that it was very accessible in that way. We also wanted a way for the court users to enter in the negotiation and mediation space, which is the actual ODR component of our system, and then to resolve their case through either a dismissal, a judgment, or a final order. So you'll see in the slide that there are the lighter colored pink circles. These are really what the steps that take you out, a court user out of the system that we're building. So we wanted to make sure that there was a way for court users to opt out of this process. And that would be if they had a challenge using technology or any other kind of challenges engaging throughout this online system. So for those folks, they would opt out and then they would go to court. Again, there's the service piece. So if a plaintiff were to initiate their case in our small claims ODR system, they would still be provided instructions to serve the defendant in a more conventional way. So because we don't have defendant's email addresses in the system, usually the plaintiff doesn't have that information, the service and notice needs to go out in the more traditional sense of in person, or in the state of Hawaii, we are able to serve the defendant using mail. At that point, the defendant does also have the option to opt out of the system for the same reasons of no access to technology or any other challenges that would not allow them to participate in this process. And again, if they do opt out, they go through the traditional court process of coming to court. So I should say that our system is built for post-filing ODR. So court users would need to file their case first, start in court, and then they would be referred to the ODR piece. We are also working on a component where if the parties do consent and or have an agreement with each other and fail at negotiation, fail at mediation, to request the court for a judge to review their dispute online, and so that nobody would have to come to court, and the judge would then render a decision at that point. The judge would review that request, and if the case is not as clear cut by looking at the records and the documents that are submitted by the court users, the litigants would still have their court date to go to. The other thing that we thought through was if the defendant never registers on the online dispute resolution portal, what would happen? So our thinking was that we were not going to default anybody for failure to go through each of these steps in our system, but they are required to come to court. And if they are properly served and noticed and they fail to come to court, that's the only time that a defendant would be defaulted. So again, this is our pilot. We want to be able to test out what we've built, how accessible it is for court users, especially those without an attorney to use. As we thought through the system, it became more of an online program than it was just an ODR. We found that what we really wanted to build for our court users really has a component for ODR, but it wasn't just an ODR platform. By the time that we completed our thought process and started implementing a lot of these pieces in our system. And again, we really were focused on what the user's experience was. We certainly didn't want to create any more barriers for anybody to access the courts through an online as opposed to an in-person process. And so we have been working very closely with the vendor that we chose for this to make sure that we're not creating any more barriers. And in fact, we're hoping to decrease those barriers to accessing the courts. We also wanted to make sure that this was a free service to the court users. It is a small claims case, so we didn't want the process to cost anybody more than what the actual money dispute amount is. And so if anybody needed an attorney to get through the system, then it's not the system that we want to have out there for court users. So with all those things, we're very mindful of how we're building this, how we're implementing it. And hopefully that's what we come out with at the end. And speaking of that, we have been working on our system for about a year. We can configuring the software. Because of the pandemic, we have been delayed in our implementation stage, but we're hoping to have this software released sometime this fall. Fingers crossed that nothing else happens with the pandemic. But again, the name of the game these days is to be flexible. So hoping in a few months that I would be able to share with anybody who's interested in what's happening in Hawaii that we've launched and that we're actually making use of the system. So that's it for Hawaii. With that, I'm going to pass it on to Stacy in Alaska.
Thank you, Michelle. Well, I'm going to bring you to another remote location, part of the continental North America, and share with you our experience from Alaska, which has been a cautionary tale of unexpected obstacles, but we are now going in a new direction. So it's been a really long and winding road for our process. Not quite as long as Hawaii, because our journey started in May of 2018 when we attended the Western States CCJ COSCA conference, where there were presentations about online dispute resolution. And our Chief Justice Joel Bolger got very excited about this concept. And then my predecessor, Christine Johnson, who was the administrative director, was also excited. And I as well attended. I had been overseeing our self-help and ODR, ADR programs. And we came back to Alaska and thought this is going to be a great solution for Alaska. This is something that we want to take on for our state. So our mission, probably similar to many courts' mission, involves making sure that we have an accessible forum. And so like Michelle mentioned, we're looking at this as an access to justice project. And like probably all the courts, we share very similar characteristics in terms of the number of self-represented folks that are navigating civil processes by themselves. And we thought this was a great solution. And so we came back and really got busy starting to plan. And one of the main reasons that we thought that this would be a really important solution for Alaska has to do with some of our geographic considerations. So if you haven't been here, this is a map of Alaska and it's superimposed on the United States. We are not in the middle of the United States, but we're to the far northwest. And our geography creates a lot of unique circumstances for us that really dictate how we make decisions about providing access. And while we have some extreme situations, I think we share a lot of characteristics with the lower 48 states because they may be extreme, but many states have the same circumstances to some degree. But Alaska, as you're aware, has some big geographic distances that people have to have to travel to get between where they live and other locations. 90% of our communities are not connected by a road system. And so the main forms of transportation really are flying by airfare, which can be quite expensive. In the summer, you can travel to some places by boat, in the winter by snow machine. But really, to get around, you really need to fly to many of our communities. We do have relatively high internet connectivity between our communities and other places, because so much of our commerce and people's lives really have to involve getting information and services and products online. So even though folks may not have internet necessarily in their own home, there's somewhere in the community that they can tap in. Usually that's the school or the public library through the school. And so this is two maps. The one on the left are our court locations. So each of those dots represents one of our courts. And on the right is our road system. So it really shows there's not a lot of overlap between our court locations and our roads. So as a consequence, it's literally been decades that we have been offering remote services for people to access court services, including proceedings. Because if we didn't, we basically couldn't operate. We don't make people pay to jump on airplanes to come to court, and we really recognize the burden it is to resolve court proceedings and disputes. So we have, every one of our courts have been outfitted with phone systems so people can call in, and we've been doing some shifting during the pandemic, of course, like everybody, to enable more video hearings. But we have long operated with remote proceedings and many other remote services. So that is a natural fit for us to be able to consider ODR. And that's why it wasn't really a big stretch when we learned about it, that it would be a really important solution for Alaska. And I'm going to echo what Michelle said, that leadership from the top, or having a champion, is absolutely critical. And so similar to Hawaii, our Chief Justice also sees this as a really important solution. And now I'm the administrative director. I stand in partnership with my Chief Justice and think this is a really important solution for Alaska to increase access to justice. So when we got back from that COSCA CCJ meeting, we ended up getting busy right away, and we pulled together a variety of stakeholders to start our planning process. And we started looking at different case types and analyzing numbers, case dispositions, default judgment rates, time to disposition, a whole bunch of different court metrics to really decide what did we want to pilot. And we came down to that we thought we would start with traffic, because it seemed like a high volume proceeding that has a relatively short timeline and not a ton is at stake, although of course every case is important to everybody involved. But we thought if things didn't work out well, it wouldn't be too terrible, and we'd be able to figure out a lot using traffic and then maybe transitioning to other case types. So that's what we started with. And we quickly got to the place, after a lot of iterations, that we had a plan. And we thought it was a pretty great plan. And we had redesigned processes and simplified things, and we were pretty proud of ourselves. And then we decided we would vet it with some more of the stakeholders. And that was particularly our law enforcement community, both on the local level and on the state level. And that's where we really started to hit our roadblocks. We met with folks. We started to find one issue after another that was something that we had not anticipated, that really was throwing a wrench into our really nicely prepared plans. We found citation issues, we found ordinance issues. We learned that police value the courtroom time for other kinds of cases, so they were using traffic as a training ground, that there was problems that were with uploading evidence in terms of dash cam videos, and police officers felt that they had the inability to bargain at the traffic court, because they've already bargained essentially at the stop in many cases, where they've lowered a charge based on their interaction. And then finally, our prosecutors, at least in Alaska, aren't directly involved in traffic cases. And so they didn't want to be involved in this. They were there kind of only in name only. So we really got rethinking things, and then kind of took a break because the pandemic hit, and that changed a lot of court operations for everybody. But it really made me think about a new direction, because everything going on during the pandemic has required a new way of thinking. And like many of you, I've been rethinking how do we do a whole bunch of our court operations, given that we have this opportunity with the pandemic to really rethink what we're doing, try new things, introduce technology in ways that we haven't done it before. And so I shifted my thinking in a completely different direction. And instead of going with one case type for a pilot, I thought, why don't we just try this for almost every civil case type, with the exception of some that just don't really seem appropriate, but use this process as a tool in almost every case as an option for people to try to negotiate or try to mediate, and in some cases have an online trial and see what works. Basically throw the spaghetti at the wall and see what sticks, and then learn from that experience and then fine tune as we go. So I think in some ways this pandemic, with so much change and so much innovation, has made me much less risk averse. And I have recognized that I don't think there is a lot of dangerous things at stake by giving people the opportunity to negotiate online or to mediate online. And I am much more willing now to open it up to a variety of case types and see what happens. So we are planning this, and we are about to release an RFP that's in its final stages, getting polished, put on it right now to make sure that we cover everything that we've been thinking about over these last 2+ years. Part of why I think I'm a little bit less risk averse now is because what we're thinking of is, at least for the cases that will be filed through the court system because they want to open a case, that in order to get a final order, they're going to need to get some review by a judge. And so there will be this hard stop at the end where there will be this judicial review of the cases. And so we'll learn a lot about what's meeting muster at that phase. So some of the specifics that we're looking for in what we're going to be asking is that we want to see 3 workflows that can be enabled or disabled by a particular case type. And that's the online negotiation space, which would be just between the 2 parties. If they wanted, they can go into another option, which would be a mediation space that would be facilitated by a third-party neutral online, either asynchronously or with a synchronous option that they can do it in real time upon scheduling with everyone involved. And then third, some cases we'd like to enable an online asynchronous trial option. And all 3 of these workflows we want to see have be able to be time bound, that there would be a certain amount of time that each side is supposed to respond, and there would be a certain number of back and forths that would be allowed so that this process wouldn't go on and on. We're also looking that the platform essentially be portable between case types, that we're not looking for specification between the case types. So I want a real simple look that is not really customized for a specific case type, but instead will integrate with other information that we have created online, and we'll be pulling in that case-specific information in terms of the education, what options exist, and the forms, including specific agreement templates. And then finally, we want to see a pre-filing or a post-filing option, and then the trigger for whether or not you need to have a case filed if you're starting at the beginning would be whether you want an enforceable court order, and that would trigger the need to file a case as well as the need to pay the filing fee or have your filing fee waived. So I want to be able to offer this platform to folks that are going to come in and they, in the end, decide they don't need to file a case because the agreement that they have reached, if they do, is simply satisfying enough without needing to have an enforceable court order, or they can file and know that they want an enforceable court order and then they would start the case, or they could already be within an existing case and give ODR a shot. So we're trying to be pretty flexible and open to see what works and basically use this whole process as a big pilot to figure out if this concept is workable or if it needs refinement. And I'm sure we'll be iterating as long as we're doing this, because it'll probably change many times as we get more information. So that is where we're looking right now. I hope things won't change a lot more because I'm really anxious to get this off the ground, because we have been in a planning process for quite a long time. And this pandemic has really given us the opportunity to jumpstart this. So I hope our RFP is going to be on the street within the next few weeks, and we'll get this process off the ground. And hopefully I'll be able to report back at a future NACM conference that hopefully we have had success, but we have learned a lot. And next, I'm going to kick this to my colleague in Colorado, Sharon, and she's going to talk about their experience there.
Well, thank you very much, Stacy. And I want to say, I think that the order of presentation for this session was wise because Hawaii, Pew, first of all, is way out in front. And they're studying the data surrounding this issue. And then Hawaii is in the lead, and then Alaska, and then Colorado. So a little bit about where Colorado is. We're located in the central part of the continental United States, as you all probably know. We have 22 judicial districts, and interestingly enough, like Alaska and Hawaii, we are a unified court system. We also were the recipient of an Access for All grant. And one of the recommendations that came out of that grant was to look at how to support the rural areas in Colorado in accessing mediation. My title, I'm actually the director of the Office of Dispute Resolution, and our primary service is to offer mediation services for those court customers that are court mandated to go to mediation. And so with that, we picked up from that recommendation, and then we, at the same time in Colorado, when I first began in this position, we had about 5 people in the office at the administrative level, and then within about 2 years that dropped to 2 people. So our key business issues that we were looking at from an administrative standpoint were access to justice, as has been pointed out by the sister states, and then our business model. We needed to create a highly efficient business model with the decline in personnel dedicated to the office. So also similar to Alaska and Hawaii is Colorado has some geographic challenges in that it has quite a few high mountain passes. We have this mountain range called the Rocky Mountains that divides our state, and many of those high mountain passes are over 12,000 feet. So the standing joke in Colorado is that there is summer and then there's winter and then there's construction season. So many of our courthouses are located at great distances where folks live, and traveling in the wintertime is often extremely hazardous. And so that was another business reason that we wanted to make sure that we could accommodate and make courts easier to physically not imperil folks traveling to a courthouse. So with that, here is a brief timeline of the work. I mentioned that we had a staff reduction or movement and changes at the state court administration level in 2015 and 16. And so we were looking at different business processes for administering actually mediation services across the state. And in 2017, we started looking at online dispute resolution tools as a way to meet the access to justice and efficiency needs for our offices. And so in 2018, we had a busy year in that the advisory board that was my advisory board for the Office of Dispute Resolution really had, after 20 plus years, felt that it had planted the flag on top of the mountain in that mediation became part of the warp and weft of our judicial system. It was extremely acceptable for parties to go to mediation to resolve their dispute. And so with that, though, they recommended to our Supreme Court that the Supreme Court look at ODR as a way to increase access to mediation services for those ordered to mediation involved in our court system. And then in November, the National Center for State Courts invited Colorado to participate in a meeting regarding online dispute resolution. And I would say it's okay to be a latecomer to this game. I consider Colorado to be a latecomer for the reasons that have been articulated before. I think that courts are different than eBay or other private business-to-business online dispute resolution services in that we are guardians of due process and notice to parties. And so we also at the same time wanted to make sure we had a good understanding of what the arguments against online dispute resolution were. So going into 2019, Pew Trust went ahead and launched the Modernization Initiative, and Colorado was a part of the process states for that initiative. So when I came at this, I had a Supreme Court liaison who was very technically savvy and very supportive of the process. And so again, echoing my sister states, it's very important that you have support at the top. The state court administrator has likewise been on this journey with me from at least November of 2018, and he has been a champion in supporting the project. And so again, even though this might arise at the grassroots level, it's important that you do have that leadership at the top. And so how we went about approaching this was to actually draft an IT charter, which is a document that outlines governance, how the governance of the project is going to be basically conducted, as well as a timeline, and that timeline can change about 4 or 5 times, but it's important that you start out literally on the same page. And we presented that IT charter to our IT department. IT departments are right now are under a tremendous amount of challenges as far as priorities and what they put in front of them. So we wanted to make sure we put this in front of them early, and we're very considerate of their resources. And then we basically started our governance group, gathering those and meeting regularly. We met via WebEx and posted all the materials on WebEx Teams, as well as included recorded meeting links, because I wanted the governance group that I was working with to be very comfortable with online tools. And so that was kind of a value add. And then at the end of 2019, ITS underwent a huge reorganization, and we had to basically make sure we were going to again meet with the court's prioritization, and we were able to clear that hurdle. And then COVID hit. So the good news, I think I mentioned the IT charter. I can, for those who might be interested in seeing what an IT charter looks like, just reach out to me during the chat, and I'll be happy to send you the draft that we utilized. And so, as I mentioned, the IT charter has these main elements, and it is important, even if you revise the charter, to have a clear sense of what roles and expectations are, and then you can always amend your charter. The ODR working group was mostly internal stakeholders. However, we did reach out to some key community players, including the Denver Public Library. And they receive a lot of inquiries from folks who want legal information, access to justice coordinator, and other members in your community, including language access folks that, although in our first iteration it will be in English, we need to keep in mind ADA language access issues as we roll out these tools. So this gives you a schematic of who is involved in the governance group. And we, again, right now have changed this a little bit, which I'll discuss at the very end of my presentation. And then, as has been mentioned before, you need to select your case types and then develop your hypotheses and look at the data to determine whether or not the court data actually will be able to support or refute your hypotheses, or whether the tool that you're purchasing will be able to collect the data that you need. So with that, ironically, the population that we are going to roll our ODR tool out is outside the courts. We are going to be piloting with child support teams in some select counties, a co-parenter app that would allow the parties to be able to come to agreements regarding parenting time. And then if they reach agreements, then the child support establishment worker can hand off those agreements to the county attorney, who in Colorado can file agreements in child support cases regarding parenting time. So my take home would be that even if you cannot start an ODR project first within your courts, look for opportunities with partnership agencies to start. And then we will in the next year be rolling out and we're probably going to start with a domestic relations tool. And then, as Alaska has determined, just look at a global civil platform. So with that, that is the experience here today in Colorado, but stay tuned. Be flexible, be polite, but persistent, and don't be afraid to jump into this because our court users need that. And with that, I'll turn it back over to the panel for any questions and answers.
Thank you, Michelle, Sharon, and Stacy. I really appreciate you guys taking the time to talk to us about your experiences. And there was a lot of information packed into there. And we only have a few more minutes, but I did want to just touch on a couple questions that kind of highlight your shared experience. Each of you talked about how critical it was to have a judicial champion or have the support of leadership. And I was wondering if you could just speak to how you identified that judicial champion, or how you actually came to have that supportive leadership, if there's somebody that you already were partnering with or had a close relationship, or how that came to be.
Well, I'll jump in. I think I highlighted that. I had my Supreme Court liaison had seen demonstrations that I hosted during meetings. So a big part of that, I think, is getting the education for your champion. But once they see it, usually they're very enthusiastic about it. And so I had a Supreme Court liaison that was very accessible to me, and I could show some tools to. And that person was very excited, as was the court executive who saw the tools as well.
I wanted to jump in because Sharon raises a really good point. As I mentioned, our Chief Justice had seen a presentation at a national meeting that I attended, and we all got on board really quickly. But as soon as we got back, we started setting up demos with vendors, and I made sure that the Chief Justice and the Administrative Director at the time were able to attend those demos so that they continued to be able to be exposed and learn and feel the excitement of the project. So I think once you get them involved, you have to keep them involved to whatever extent you can, at least keep them apprised. so that they know things are moving ahead and they feel part of the project. So it's not just a one-time thing. I think you have to keep nurturing that relationship so that their interest continues.
And I think that's similar in Hawaii. Our Chief Justice is the main champion of the project, but he also designated a judge within the district court to really kind of shepherd the project along on the kind of the more day-to-day aspect of the project. And I think having a judge on your executive panel on your project is really important, because if you don't have 100% buy-in within your court staff or on your project, the judge will step in and say, well, here's what we're going to do, and it's a great tiebreaker. It also shows our external stakeholders that there is real commitment from the judiciary, and it wasn't just something that's being thrown out there and, the new exciting tool to have. It really is an invested thought process and of the time and resources for the courts.
Thank you so much for sharing that. I think one other question that's really critical and that might be on people's minds right now, especially given the pandemic, is how are you funding this? How is your funding model shifted, especially as we know some courts are cutting budgets or things are shifting in general. So could you talk a little bit about that?
Well, I can just say that from Colorado's point of view, because we are working with our collaborative partner, Child Support Services, we are using federal funding, which is Child Access and Visitation Grant, to lift this project off the ground. And the federal government administrator has been very supportive of that. We have run online projects before with this population. We're trying to increase our reach and the number of folks that we serve through that grant, and we think this will be a wonderful project to do that.
For the state of Hawaii, we were fortunate to have put aside our budget for the implementation stage of the project. So that is not something that we're going to have to chase until the end of the project. It's already set aside for us. But there is an ongoing cost because we did decide to do a commercial off-the-shelf software. And so with that, it is still a minimal cost, but with the challenges with the budget, it could potentially become a challenge for us. With the pilot phase, though, our Chief Justice is committed to not passing on those costs to the court users. So that's what we're going to continue to do. And as hopefully the budgetary challenges for the state won't continue for a long period of time. But again, mindful of that, we're thinking that there's going to be a payoff because this is an online solution, and so there's going to be some cost savings on the judiciary side for making this streamlined for the court users, but also for the internal court staff.
And similarly, the Alaska Court System plans to absorb the costs. We're not planning to pass it on to the users. We are using some of the funds that we received, federal funds through the state, through CARES Act, to launch this project. And like Hawaii, we hope that it will also pay off in the future because there will be savings in other areas where cases are resolved largely through the platform. Maybe some people actually never file a case, so they never come through our actual filing doors here. So there's a lot of data that we'll collect to assess the value, but we hope it's a good investment for access, as well as there may be some payoff in terms of diversion of work as well.
And then she's like, what? Great. Well, I think that is all the time that we have for today, but I, again, really appreciate all of you sharing your experiences. It's been really enlightening, and I am hopeful to see you back again and hear more about the lessons that you've learned in the future. So thank you so much.
Thank you.
That's it.